I'm going to turn the recording on. So this is LAWS12066 Land Law, and this is a consultation session on the 20% assessment. And we're just at the minute talking about the Part B with regard to completing the national mortgage form inside PEXA. And yes, I mean, some students have indicated that there's been some, a couple of technical challenges there in relation to the completion of the process. Don't forget, folks, that I actually indicated that you didn't need to go to the point of actually lodging through the system, because that required further steps and further arrangements with...
I didn't try to lodge. What I tried to do was sign to get her, be able to get that, screenshot for the mortgage.
Yep.
And the second time, after like it had, killed itself at midnight, even though I'd saved it, it was there. I came back and it had already done that for me, but it hadn't before then. So according to the PEXA thing, it said you have to do this next step. And when I pressed that button, that's when I was in this disaster.
Well, I mean, with these processes, sometimes there can be some, technical issues. We appreciate that. As with all technology. But I still believe that it's an important skill to acquire and to experience. And you're the only law students from Queensland University that are having this opportunity. You might say, well, it's a bit of a challenge, but it is the future, folks. Okay, so I know that electronic conveyancing hasn't been mandated in Queensland yet, and that's still, a matter to be considered by those who make those decisions.
So on that point, can I just ask a question? Because in the video that you posted about the assignment, you said that little b of Part B was really about our experience and what we thought about it and, critical analysis of it. So, there's no references. That's really up to us to just write what we see as despite my discussing situation on Saturday, but what is it exactly that you're wanting from us? It's not reference,
It is about documenting, right? So you've undertaken in part in small a of capital B, you've undertaken the process of completing the form inside the PEXA training environment. Yes, right?
Yeah,
when we come to part small b within capital B, what I'm then asking you to do is to reflect upon that experience of how you did it, right, and what was required. Comment on, maybe there was a few challenges and so forth. But the purpose of the exercise is also for you to comment on, or what are your thoughts about whether electronic conveyancing should be mandated in Queensland, because it is already mandated in 3 other jurisdictions.
No.
Right, well, you can have your view on that, Mary, and that's fine, you can express your view, but the reality is, going forward, that is where we are moving to, okay? And the movement is even advancing further than just talking about the method of electronic conveyancing that we have now. We already have, this is within the context of a land law course, so we're doing this as part of a strategy to see how documents and instruments within the land law environment now occur electronically. And one of the reasons I chose the NMF was because it is the first form or first document or instrument, if you like, that is a critical document, a mortgage, that all of those jurisdictions that are signed up to electronic conveyancing have agreed to a standard form, which is now the standard form that all of those jurisdictions use. And it is available to be, and it is, jurisdictions are signed up to it, even if you can do it, even if you're not progressing through PEXA. That form is available through the ARNEC website, and it is a standardised form that's been developed. So prior to that, we had different forms in different jurisdictions and so on, because we've still got this state-based system of land registration, as we know. So that was to show you that and to let you have a chance of seeing that. But small b within capital B of the assessment is just to get you to comment on your experience of that, working through the process of it, what's your thoughts on that, and then in light of that, what are your what thoughts or comments do you have to make about this idea of moving towards a mandated electronic conveyancing environment? And some of you may think that's where we should be heading. Some of you may well be saying, no, I don't think that's the stage we're at the moment. But I want to, we'll explain why is that the case. And then if you do, for example, say, no, I don't think that we should be moving that direction, how do you reconcile that with the fact that other jurisdictions are already there? And the reality is that practitioners and lawyers in the property law space will be involved in transactions actually across jurisdictions. That's the reality of the electronic environment. So you will no longer be operating within one jurisdiction, okay, as historically was tended to be the case with lawyers. The impact of all of this is that you will be operating multi-jurisdictionally, and then the further implication is going forward, we're not probably quite there yet at the moment, particularly with some of the protocols that are in place, that you can be undertaking transactions beyond the Australian landscape that is relevant to land transactions, in this place. So, I'm talking about, for example, foreign investors wanting to purchase properties or involve themselves in land transactions. They can have a lawyer that's based in the jurisdiction. Why wouldn't they? That would be the most appropriate thing to do. And the electronic environment facilitates that. But there are also challenges, absolutely. And there are also risks. That's true. And that's just that these are factors that need to be thought through and reflected upon as we progress. Other questions, other queries, issues? Hopefully you've all had a chance to see and review the recording that I've posted up in regard to the assessment.
Yeah, I did, Michael. It was rather helpful actually before I started doing the PEXA thing. One thing I did note about it was when you said we didn't have to sign the document or go through. I found a way inside the PEXA system where you can actually get to that document you've asked for us at the end without actually having to go through the signing process. Okay. I've shown people in that video I've created exactly how to do that.
Very good. Okay, that's great. Thanks, Nicholas.
But that's actually already set out anyway in the PEXA, one of the PEXA uploads each step that you go through anyway, which was what I was going off.
Yep.
So I don't need a video. I mean, it's there in black and white. I read it and I went through every step.
Well, that's why I put those materials on the Moodle website for folks. And I think there was a very good set of materials developed by PEXA explaining a number of different documents. And I put them all up there, and then I've actually directed you to the specific ones that are relevant to the assessment.
Said don't go on to register it. So, like, every single stage was very clearly set out.
Yeah. But the issue is, and I think this is Mary's point, is that sometimes with the technology there can be a glitch or something like that occur, and we just have to understand that and working with it. Sorry?
I said 16 hours worth of a glitch. That's what it was.
It's not, I don't know. Sometimes, I apologise. It's been frustrating of that kind, but don't forget also that.
Apologise. I'm just saying that everything else on my computer worked. So I tested everything. I made sure there was no caches or viruses. Did everything, but couldn't get anywhere. It was just stuck with this dotted circle going round and round and round and round.
Well, hopefully that's been resolved and you've been able to complete that part of the assessment.
I was at the end of that time, and when I went there, it was fine. I just had to actually, because I'd saved as I went, just open it up.
And don't forget, Don't forget also, people, that, you know, that part of the assessment is only for 3 marks. You know, I haven't allocated a great bulk of the marks to that part of the assessment.
And that was the time frustration for me. 3 marks for all that time.
Well, yeah, I'm sorry about that. So, other issues, questions, queries? Alison?
Michael, I'll go. Just been waiting to jump in. Part B was fine for me.
Yep.
Like Speen already said, it's set out pretty easy on the instructions and how to do it. I'm just struggling to get my head around Part A, and I have watched the additional video that you uploaded on the weekend.
Yep.
I suppose I'm a bit hung up on the fact that I feel like typically when you read a case scenario, our job is to provide advice, so come to some sort of decision of what way we should be going. So I kind of feel like with providing that advice in the first instance and Part AA, the information in then Part AB is going to be duplicated but written for a different target.
Can I respond to that? Is that okay?
Yeah, sure. Yeah.
So I think that's up till that point, the comment you made, that last point. That's, yes, I agree with that. The purpose of the second part, right, is firstly to flip you around and to look at it from the perspective of the other party in the transaction, rather than, you know, most of us will be in situations where we would ordinarily be advising an owner in this scenario / mortgagor in that type of a transaction, and what their interests are and how they might challenge something and so on. So the purpose of Part B, as a small b in capital A for 6 marks, is to flip you around and to look at it from the mortgagee's perspective, but also to get you to think about the processes that need to be undertaken and followed, and how much the scenario requires that to be pursued. That's really, again, thinking about, well, how far has the electronic dimensions gone on the facts, and then what are the steps and stages that the bank the mortgagee needs to ensure that it's met, and are there any issues around that, and how does that work? So that's really it's not Part B. It's not intended, small b in the first part of the assessment. It's not intended for you to repeat the story from Part A. No, that's not intended. If you think that you want to say, well, I've discussed this in Part A, and that's, I'll just acknowledge that, that's fine. But the purpose really is to get you to think about it from that different perspective of the other party, the bank, the mortgagee's interest. Don't forget that the mortgagee, of course, is trying to ensure that their interest is secure. Yeah, and if there's queries about the process, is there any way that they can overcome those? Or you might come to the view, no, there isn't. But it's just to get you to think from that perspective, and also to think about the process and steps that need to be adhered to. That's really the driving purpose behind little b. The other thing I'll just comment on is that I've had 1 or 2 students say, well, I think I might have commented and mentioned this in the recording, that, well, we don't normally act for both sides in a transaction, Michael. There's a bit of a conflict of interest there, isn't there? Again, this is in the context of this academic exercise. So I don't need you to investigate the idea of a conflict of interest in terms of ethical obligations in that sense. That's not the purpose of the exercise. It is just to get you to see things from both perspectives, and also to think more really in terms of the sorts of matters that the mortgagee needs to focus in on, in terms of what it needs to do to make sure that its interest is secure.
Okay, so I suppose that makes sense. I've never had an issue with the whole we wouldn't normally act for both sides. I think it's fairly obvious that we're students and that's what we're trying to achieve. I think, yeah, I'm finding the case law quite challenging personally in this scenario as well. So, but I suppose.
Sorry, did you say the case law?
Yes.
Yeah. Right. So there's another point that I wanted to, and I think I made this in recording, but I can repeat it and reiterate it. One of the challenges we have here is that what I'm trying to get you to do is to see how we can, and you know, all lawyers will need to do this going forward. How do we use the body of case law that exists that essentially has been about resolving disputes in paper-based transactions and disputes that have arisen out of paper-based transactions. How do those principles of law that come from those cases work and apply in a context where there are electronic processes, as you know, in terms of how the transaction is taking place? Is it a seamless application? Is there some issues there about how we apply it? So that's part of the purpose, to get you to think around that aspect as well. And it's just putting you into the context, really, folks, of reality. And I know this is a bit challenging, because you might say, well, but Michael, the materials are as they are. What else am I supposed to do? Well, that's exactly what lawyers are facing today. And if I were to give you a scenario that just puts you back into the past in this situation, I'm not really, testing those skills that you need going forward in a changing environment of how lawyers function. So the purpose here is to see that you've got a grasp of the framework of law, right? Legislation, case law, and the guidance, for example, from the Land Title Practice Manual. Got a good, firm grasp of that. You understand how that works and fits together. And then you're showing me some arguments or evidence that you're finding ways to apply it into the context of a scenario that has electronic features in terms of the transactions and events. And you might find that, the current body of case law, for example, will only go so far, and you'll have to actually seek to argue it into this new situation. And I'll be interested to see how different students do that.
The other question that I want to ask about part A, little a, is because I'm towards the very end of the law course, and it's supposed to be an advice to the client. Do you want us to, because of the word limit as well, just concentrate on the law and case law, which has been difficult to try and, I can't find a parallel case so far. So you've got to use, arguments from the way other things were handled in terms of like similar things, but different kind of scenario and, different things. But do you want us, like, what I've been taught, and I've done ADR and all that sort of stuff, is, this is a brother and a sister that have been obviously close and worked together for a long time. Do you want us to even go there in terms of, can this be mediated out? Is she prepared to, pay back the loan, sort of thing? Or do you want us just to concentrate on the law?
Look, that's a good question, Mary, and I think it's a good point to bring up that a scenario like this may well lend itself to those other dimensions, but you have got a tight word limit, right? And that's acknowledged. And so I want you to focus on the land law features, okay? I'm very happy for you to maybe just in a footnote, sort of note that you're aware of those other things that could be done. And so that shows me that you've got a bit of a broader sense of, how you might go about trying to resolve things. but I want you to focus in on the land law concepts and principles. The whole purpose of this exercise is to get you to work with that framework of law, the body of law that we're studying in this unit, and apply it to this situation. You've also commented on the fact that, oh, I can't quite see a case that's on all fours, and how do I? Well, folks, that's reality land. You know, you actually don't find situations arising that are on all fours with the law. You've got to work with the law, and you've got to find a way to see how it can inform your client's position in the way that is in their best interest, really, as far as the law gives an outcome for you. And that's the role of every lawyer.
Michael, if I can just make a comment, well, more of an observation, I guess. I mean, part A and B, and I know you said we're coming from a standpoint of arguing for both sides. One of the things that I have taken conscious efforts to note, other than the Queensland legislation, is that throughout our readings, there's a lot of references to New South Wales, Victoria cases and whatever. And I come back to this point that you made earlier on, and it's been judicially acknowledged that one must take care to make sure that you're focused in on the legislation and or cases that are relevant to the jurisdiction you're in. One of the things that I took a really good notice of was that you pointed us to the it's in section 5, page 530 odd something, I think it is that reference guide to what point in, let's say, New South Wales is equal to the same point in Queensland.
Yep.
So what I was doing was sort of observationally making these comparisons, reading a case and going, okay, well, they've based it on this provision in New South Wales. Is there an equal provision in the legislation in Queensland that can affect that I can say, well, I can use this case because I can reiterate it back to a similar provision within the Queensland legislation?
That's well spotted, Nick, and thanks for pointing that out, because, and I think I have tried to emphasise that, and I think this is one of the challenges. I think there's a few challenges in land law currently. One challenge is that I believe that there's been insufficient focus on the difference in the legislative provisions between the jurisdictions, so that there just has tended to be, particularly in the way that this area of the law is taught, that oh no, well, this is a general point. I mean, let me give you an example, right? Which is, I think, beyond, outside the context of the assessment, so I can use this as an example. So, in the area of the exceptions, rights in personam, Queensland has a specific section, 1851A, dealing with the personal equity exception. Other jurisdictions do not have such a provision, and the rights in personam exception arises out of the comments made by Lord Wilberforce in Fraser and Walker, that there will be these rights that derive either from law or equity, and they exist outside of the torrent system as a result of obligations entered into, promises made, contractual undertakings of, whatever. So when we come to think about that in Queensland, right, we've got this large body of case law from all different jurisdictions. A lot of it, not entirely, but there's quite a bit of case law, for example, emerging out of New South Wales and Victoria, where there isn't an equivalent provision to the one that we have in Queensland on this issue. So one has to ask, well, where there isn't such a provision, is that body of case law that's coming out of a jurisdiction where such a section doesn't exist, does it seamlessly apply into situations and fact scenarios that arise in Queensland? I would put to you that no, it doesn't, doesn't mean it's irrelevant, but you have to think about how you're going to apply it in the context of the legislative provision that we have in Queensland. Now, I think I'm on good, safe ground in this method, because in Casagran's case, and I pointed this out both in my lecture and also in the tutorial when we covered that case, that's precisely what the High Court has said. The High Court has said you must look to the provisions of the Torrens statute that's relevant in the dispute at hand. So that for us, and I know that we've got colleagues in the unit all across the jurisdictions, which is wonderful, but we are studying this unit against the Queensland legal framework, right? And that's the primary law that we're using. So we need to, and that's why I've been emphasising, we need to go back and look at those relevant provisions and look at the wording of those provisions. Now, obviously, we're not needing you to look at the entirety of the Act, because that's vast and whatever, but the relevant provisions that we're focusing on, you need to always, and this is with Torrens disputes and Torrens issues, you need to start with those critical sections in the Land Title Act. Then you need to go to the body of case law, and it becomes relevant and applicable to the extent to which it is helpful and it's appropriate to apply it in our interpretation of the relevant provisions in Queensland. If we are actually talking about something that's off legislation, right, so it's about general, the jurisprudence that's developed around the arrangement or around the framework, the extensive body of case law can be accessed and utilised. I mean, let me give you another example. So, in the critical area of indefeasibility, okay? In Queensland, in the Land Title Act, the word indefeasibility actually is found within the Land Title Act, within the Torrens Act. All right? Other jurisdictions, there's a different picture in different places, but in other jurisdictions, for example, New South Wales, Victoria, some of the big states, for instance, where there's been a lot of disputes that have arisen over time and so on. No, we don't find that word indefeasibility in the Torrens Act, the relevant Torrens Act in those jurisdictions. What we find is a concept within the wording of the relevant provisions in those acts, or what's referred to as paramountcy of title. Now, the body of case law has spoken about this notion of indefeasibility, but often it's being spoken about in a way that is trying to capture what this means in those places where the word isn't actually there. So where the word has actually been put into the statute itself, arguably it tends to change the focus of the discussion. So yes, absolutely, you must start with the provisions of the legislation, and you must look at and carefully scrutinise the wording, and then you can bring in aid the body of case law as appropriate to assist in that process of understanding how those provisions are governing this situation, if it's about those provisions. Right? So, and as we go forward in subsequent topics, and I know that's not for this session, but you'll see that we'll start looking at provisions, for example, within the Property Law Act that we saw in the Term 1 course, not the same provisions, but we'll be looking at that as well as the Land Title Act. But in these topics dealing with the Torrens system, our primary focus has been on the LTA, which is our Queensland Torrens legislation.
Michael, just another quick question in regards to, let's say, High Court cases. So we've got High Court cases that have come down.
Yeah.
How influential, or is there more influence in a High Court case, let's say, than in a case that was from New South Wales if we're dealing in a Queensland context? In other words, if I'm dealing with an issue in Queensland, what would have more weight? Would it be a High Court case or let's say, a New South Wales case that has an equivalent provision to that which exists within Queensland?
Well, that's a good question.
Can I just add to that? Because this is the problem that I'm finding, that even in the higher courts, like the High Court or the Supreme Court decisions, when I've studied the cases, there's no equivalent. So is that where you can try and bring in a statutory interpretation kind of argument perhaps for the Queensland, the Land Title Act and that in Queensland, even though the laws are fairly specific and descriptive, I know, but does that, as Nicholas is saying, things that have been decided in the High Court covering, we always look in other areas of law to High Court, Supreme Court decisions, right? But because Queensland's got its very own sort of very significant kind of legislation, the thing is that so much of what I've studied in the cases, I then can't use it because there's nothing applicable, and I've tried to look at a statutory interpretation sort of argument. You know what I mean? Is that what I have to do?
That's fine, Mary, and certainly bring to bear, thinking around, how the relevant provision should be interpreted, where you find that there is a gap in terms of case law. That's fine. I'm just interested to know, has anyone else got a view on the point that Nicholas raised about, does one go to the High Court authority? Does one go to, Supreme Court or Court of Appeal authority in another jurisdiction when it seems to be more on point with regard to, interpretation of an equivalent provision? Has anyone else got a thought on that?
Yeah, I think that you can use it if it does come to an equivalency within law, the way you've designed the assignment based solely on the Queensland legislation. That's my thought on it. That's where I'm sort of trying to drag bits and pieces from. Because the text is New South Wales based and there's very little Queensland case law in it. And if you go to the case law and search through Queensland case law, there's still not a lot on it. Do you know what I mean? And that's where I've struggled. And Part A, I've spent ages and ages and ages on, not to mention the Part B, we won't even go there. But that was a tech hitch. But this is where I'm finding it very difficult, and that's where I agree with I forget who it was now. Was it Jessica? Or it's very difficult to do that. So I think yes, where it's applicable and you can find equivalent laws, yes. But so many times I've got to that stage and I go through the Land Title Act and I can't find anything even near the equivalent that the decision's been based on.
I think it's more that you get the general, like if you get a general principle, there's a general principle, and if it's very similar to the case that you've got, you would use it as persuasive argument in your response.
Yes, I mean, I agree. And these are challenges that we find ourselves presented with in this area of the law, folks. Of course, as we know, High Court authority is superior, but if it's not coming out of is coming out of a different jurisdiction, the appeal is coming out of a different jurisdiction, looking at legislation which isn't equivalent to our situation in Queensland, then arguably, unless, as Melissa points out, there's some broad principle that we can glean from that decision that's applicable, then it may well be the case that Supreme Court or Court of Appeal authority from another jurisdiction that has is dealt with an issue that's similar, or with a provision in their legislation which is similar, it may well bear more closely on what I'm trying to deal with. It's interesting that it's because a lot of the Mary, I think pointed out that, the case book tends to be more New South Wales focused. Well, I'd have to say yes and no. Certainly, there's a couple of the authors there, or traditionally that have been the authors in that casebook New South Wales based, but there are others that aren't in New South Wales, and one was based in Queensland, and I think she's still in Queensland. And you will see that there is reference to provisions of Queensland legislation. There is also quite a lot of Queensland case law that's documented in the casebook, which is good. But a lot of these books, as you also would appreciate, are written for multi-jurisdictional use, so that the intention is that any student in any jurisdiction in Australia can use a book like this. And to some degree, that's been a factor in me choosing this work. It's a good quality work, but yes, it's not just about Queensland. I acknowledge that, and it refers to the other areas and other jurisdictions. So you've got someone going to say something there?
Yeah, I was just going to make a quick point about those High Court cases you mentioned before. Is if they're coming out of, let's say, New South Wales jurisdiction and being taken to the High Court, then, as you have pointed out, the majority of the case is around resolving that issue within that New South Wales jurisdiction. But what I do notice in a lot of those High Court cases is that, as Melissa has said, when they come up with this broad consensus, they list a series of cases not only from within, let's say, New South Wales, but they also list cases that have a similar flow from the other jurisdictions, as in Queensland or Victoria or South Australia. And although in that particular High Court case they're not used as a main bullet point for pushing their case forward out of New South Wales to the High Court, they are used as a basis for developing that consensus idea. And what I found is that if I then go into those particular cases, I can find more of a direct link from the High Court case through those cases to the prevailing legislation or concepts within Queensland. So you can find cases, but you've got to dig through the High Court cases to find them.
Yeah, sometimes that's
the point that I'm making. It's taking so long, and as Nicholas said, these cases, but some of them are New Zealand, some of them are England. You know what I mean? And so it's taking so long to try and find those, like going through and finding those little bits here, there, and everywhere that you can use. And so I've got like bits and pieces everywhere, and then trying to, it's taken ages.
Well, it's a 1,000-year system, Mary. There's a lot of cases there to go through.
I look, that's, this sort of forensic detail, folks, is, to me, is really heartening, because these are critical skills that lawyers need. And problems and puzzles don't present themselves to us in nice little packages that sit out, sort of on all the four stools of particular decided case law. And again, part of the purpose of the exercise here is to get you to see some of that and to try and work with that. But again, within the parameters of the exercise, and just remember to keep going back to the core ideas that are being raised in the materials, and how the body of law can be used to discuss those as appropriate against the scenario that's being posed. Talking about the vein of authority, despite the fact that New South Wales and Victoria are sort of quite prominent in the sort of disputes arising and this sort of thing, and then you get a body of case law and so forth. Queensland has also been quite active over the years, and let's not forget that one of the seminal cases in this area comes out of a Queensland dispute, okay, and that is Bresvar and Wall. That is the case that decided and settled for us, and that's been accepted in Australia, the principle of immediate indefeasibility. That came out of a dispute in Queensland, and if you go back and have a look at Bresvar and Wall again, you'll see that it's discussing the predecessor legislation of the torrent system in Queensland, real property legislation that existed at the time when Bresvar and Wall was decided in the 1970s. So, we have, and the case book has many Queensland decisions from, not all the High Court decisions are coming out of Queensland, but we have some, and that's a very significant one that's had tremendous impact and lasting value and lasting effect in this area and our understanding in this area.
Again, that case lists quite a few other cases which are worthwhile going through to build that concept.
It does, absolutely. And this is, about a bit of forensic detail here, and how one goes about that process of utilising law to build an argument.
I'm confined to 800 words. It makes it difficult. What do you put in? What do you put out? I mean, the law is relatively easy, that part. The case law and the arguments that you want to make, it's very hard to keep within that 800 sort of guidance, It
is. And I acknowledge that.
So, it becomes eeny, meeny, miny, mo, which is the most powerful. What do I kick out?
I don't think it's just quite as straightforward as that, Mary. I think you, in the sense of what I'm saying, is you will know where your strengths are of argument, and they're the ones that you really need to be presenting. Your strong arguments.
That's what I mean. The more powerful one. That's
right. And you can always, if you think there's something further that you wish to document, you can put that in a footnote. Just, I don't want you to go into it extensively because that's not the purpose of the exercise. You can just note it. That's fine. I can see it. I can see that you've had a wider vista in your understanding, which is great. So you can deal with it like that. You're muted, Mary. Muted.
You wouldn't count that in the word count if we made a note of that?
Footnote? No, I don't think he'd count a footnote. Normally he doesn't.
Stretching.
Yeah,
Look, when I say, now this is, let me be clear about this, right? When the word count essentially is about text, okay? Now the qualification around that is that if students start to develop fairly long and prolix footnotes, well, that's clearly trying to get around the system in a sense, and I'm not going to truck that. Okay, so but if you've just got reasonable notes there, footnotes. I mean, I think my view is that footnotes have a purpose other than just purely for a record of citations. You can drop something into a footnote, a thought, a comment, some further vein of thinking, without going into it in detail. There's no need to do that, right? And this is not the place. You don't have the space to do that, but that you can utilise the footnotes in that way. And so I'm primarily, and I know that the issues around word length is important. Primarily, I'm focused on that word length applying to the text of your response. But I am also going to look at your footnotes to see, not just look at them in terms of the reference stuff, but to see, are you really trying to cram more in through footnotes? Okay, so
if you just say listed the case and then sort of made like the paragraph or something that you were referring to, and just said that this could also be a possible argument, because
you can do that. You can do that.
That wouldn't be counted in the 800.
You can do that. You can do that, Mary.
They do the same thing in the casebook model. Sometimes they just have a reference to a case, and other times they might have a small paragraph in reference to something else that's related. So I look at it from the casebook point and do that. I'd like to offer a personal challenge though, Michael, and I'm sure a few other people might like this idea, but I'll throw it out there. Normally when we finish these exams, we get feedback from yourself and another marker, like we did last term, and it's all in video, which is great. That's fantastic. But I'd like to throw the challenge out there. Could you actually provide a written answer within the context of the same word count that you've given us? just for posterity reasons.
I'll take that on board, Nicholas.
Yeah, I thought you might, Michael.
But no, that's a fair point. That's a fair point. But no, but don't also forget with regard to any when I do, and I do tend to do recorded feedback sessions. Because I give quite a bit of normally, reasonable feedback, written feedback on students' assessments. But this time around, and this is actually something I want to ask everyone and see what your view about this is, the uploading of the recordings in Echo 360. I've activated a transcription service on that. Now, I don't know whether people have found that useful or not. It's the other thing that this is the point I wanted to bring up was so that, in other words, what I'm saying is when there's a recording done and it's uploaded through Echo 360, then there will be a transcription of that, so that it's not necessarily going to be 850 words, but so that will be available. But the other point that's been, and I'll just make this point, Mary. Just let me make this point first, and then I'll let you comment. It's been put to me by a couple of students that actually the recordings on YouTube, uploading them to YouTube, are much more accessible than Echo 360, and that some students argue they have issues with accessing Echo 360. So I'm just interested to hear, you might notice that I've started uploading recordings, lectures to YouTube, as well as Echo 360. Anyone have any view about that? And also I'm happy so long as everyone else is happy. I haven't been uploading the tutorials to YouTube, but I'm happy to do that if people would prefer them to be uploaded to YouTube. And it's been put to me by at least a couple of students that where recordings of whatever nature are on YouTube, they're very easily accessible on mobile devices, and they can also be viewed in a lot of situations with, some students, have family situations, children or whatever going on. They've even suggested they can put it on the TV and they can watch it while they're doing other things. So I'm just interested to,
Yeah, I was going to say a couple of points to that, Michael. Yep. People can stream from YouTube to their TV, but the biggest difference between YouTube and Echo 360 is that Echo 360 has a bandwidth issue. If you don't have enough bandwidth or a decent connection, it goes to what they call a low latency, and then if it's below that, it won't play at all. YouTube will automatically take a 1080p down to 720, down to 640, down to 440, 80, so it'll work with the bandwidth you've got. So no matter where people are, they can actually get access to those videos a lot quicker and easier on YouTube than they can with Echo 360.
Can I just say something? I was trying to say something before. YouTube is better for people. I didn't understand anything Nicholas said because I'm that tech challenged, right? Made no sense to me whatsoever, right? And this happens so often with Nicholas, and he's a genius with tech, I know, but for people like me, YouTube is great. Now, with the 360, you mentioned about the automatic, what was it?
Transcription.
I tried that transcription, and do you know that it took me twice as long as the actual recording to correct the transcription?
Yeah, it's got issues. I know that, and that's the nature of the technology at the moment. It's not at all totally perfected by any means, but it's again, it's an experimental aspect of the Echo 360 software, and we were given the option to activate it as an additional service, and it was explained to us that it's not perfect. but it is a transcription of what has been spoken, mostly.
You can also do that on YouTube, Michael, and it's a lot better because you can actually set it to Australian language, so it will pick up the variances in your language, and the text will be a lot cleaner.
Okay, well that's good. Thanks, Nicholas. I appreciate that, and I always my aim always is to try and work with my students' situations and what's most. What works mostly for them, and it's not always easy sitting on my side of the table to know exactly what is the best methods of technology. And so we have a number of different features. The university puts us sort of tends to shunt us in a direction. I know that with all of my online students and in a whole lot of different situations, I know a lot of my colleagues use YouTube and so forth, but it's clear that getting a sort of a range of views there, but YouTube certainly seems to be getting a bit of a Guernsey.
I think it does depend on the device. I know that Echo 360 is very easy for me at home on my computer, but I tend to listen to recordings on the train to make use of my travel time to and from work, and it just doesn't always load on my mobile phone.
So just on that point, Alison, and then for the benefit of all, you notice that I'm also uploading not only the vidcasts, but I'm uploading the stripped audio as well. So people find that useful?
For me, I can't seem to open anything that's on Echo 360 on my mobile phone when I'm on the train.
Okay.
But YouTube works fine.
What about the audio files though of the lectures which I've uploaded?
I don't want to say I've tried it if I haven't, and I can't recall. I do not recall.
That's all right. No, I do not recall. That's a
recall.
Response, right?
I have tried it. The audio recording on Echo 360, like Alison, when you're out and about, it's almost impossible. It's like the video. There's no difference. Sometimes you'll get it, sometimes you won't. But I can go to YouTube and listen to it and or watch it. It doesn't matter. It's all there.
Well, that's good. And I mean, from what a few of you have said, then it's it's easy from my side to what I'll do from here forward, and I'll even go back. I'm happy to go back to the earlier tutorials and upload those to YouTube as well, which I haven't done because I thought there's issues around privacy and so forth. But if YouTube tends to be the more preferred platform, I'm happy to do that. It's also not an issue for me to also upload it to Echo 360. Some people have indicated that there's some issues with work and so on, and this sort of thing. Just before we move on, I see there's a question there from Eva about the 30% assessment. That's going to be released during the midterm break. Okay, so once you've got over the 20% assessment, I'll be releasing that during the midterm break. All right, so just letting you know that. Not straight away, but into the midterm break, give you a few days of respite before you need to start thinking about the next one. Okay, but plenty of time there, Eva. Plenty of time, because my aim here is you'll have about 3.5 weeks on that one. You've had almost about the same length of time on this first one, and then there'll be the final exam. So in this unit, we've only got 3 assessments, I'll ask this question as well, just as from a reflective point of view going forward. What's your sense of? So I've set. I know that in the term 1 course I had 4 assessments. Probably in hindsight, probably too many assessments for folks. But we've got 3 assessments in land law. How do you feel about that? Or would you actually prefer to have, say, I mean, we've got the exam, that's as it is, but how would you feel about if, it's not this time, but going forward, if there was one assessment, one large chunky assessment, and it came a bit later in the term?
I think if I can answer, obviously only speaking for myself, but I think 2+ exam is quite consistent with what other lecturers are doing with the 50% exam, and it breaks it up. I think the assessment tasks are pretty good once you get your head around them and the level that what you've done. I did send you an email this morning.
All right.
Just regarding everything else, which I won't get into in this forum, just with the amount of materials and my struggles with that. But yeah, 3 is good.
Good.
I prefer it broken up as well, because you can concentrate on one section and then move on to the next topic, and then you've got less to concentrate in the exam. So you're just concentrating on one section and learning that part in detail, and then moving on to, instead of skimming through everything all at one time.
That's thanks for that, Melissa and Alison. That's helpful feedback, and that's my sense. And hopefully you've seen that I've given you quite specific guidance in terms of which topics are being assessed in the assessments. I mean, you already know, for example, well, you clearly know that what topics are relevant for the assessment that you're currently doing. But I've already told you which topics are relevant for the 30% assessment. And I will also give you very clear guidance, like I did in property law, in terms of which topics are going to be assessed in the final exam. And this time around, it's 50%, not 60%. Okay? It's a
question about that final exam, Michael, because and just personally, once again, but I've spoken to a couple of other students previously, and one of the things that comes up is I like the idea that we've got it now. We've got these 2 sort of tests basically we do before we go to the final exam, but is the final exam always at 50% or more? And the reason I ask that is because if in the first 2 things that we do, like this 20%, 30%, and we're waiting for feedback, we get feedback, that's fine. But on the final exam, we never seem to get any real feedback on how we did. I mean, all you get is, anywhere from your pass to your HD at the end. So you really don't know how well you've done on that final exam and where, if anywhere, you've been let down or you let yourself down.
But that's the case with invigilated exams, Nicholas.
Yeah, I know.
There isn't feedback on an invigilated exam, apart from the fact that we provide, I do a recording with regard to the exam, which is about strengths, weaknesses, but that's just the way exams are. Right?
Yeah, no, I'm just wondering whether it's like that final exam's always at that 50 or 60% mark, or is there a possibility in the future that it may be like 30% and 70% during the term?
Historically, it's sometimes been even more, up to 70%. But I don't believe. My own view is that I actually think that 50% is about what maximum should be. I know that you'll say, well, how come you got 60% in property law, Michael? Well, partly that's about accreditation requirements and having advised accrediting bodies earlier about a breakdown, which I was actually locked into when I first designed that, and then a process you have to go through to get that breakdown approved again by accrediting bodies, and Queensland is the Legal Practitioners Admissions Board, LPAB. Not more than 50%, I would say. That, look, generally speaking, 50 to 60%. Can it be less? Well, it can be less. It's a question then, I suppose, of how much weighting you're putting on it and what you're testing. But that's, it's.
Yeah, it was just a generalised comment. I mean, I don't have a problem with it. It's just that overall, I think, as you would be aware, you sort of finish that final exam, and if during everything else you've done before that exam, you'd only recovered, like say 40% or 50% of the entire subject, you're waiting on that final exam to see whether you've passed or not. And when you do, you don't know what errors you made. And that's the point I'm making. You never get an understanding of, could I have done better? And if so, where?
But that's the nature of exams, Nicholas. And I have to say they were ever thus. Alison. And then
well, I was just going to say on that everything, most subjects that I've completed, once we've sat the exam, we get an answer guide from the lecturer. So I typically don't look at them until after I got my grade. Otherwise, I'll sit and stew on what I missed. But generally speaking, if I've got a distinction or a credit, I can then look at the answer guide that's been provided after the exam and work out where I've left.
And I've also had students say to me, well, but unless I know what's actually in my exam paper, I can't work out whether I went wrong or where I got. I mean, how far you can go down this track. So that's fine. And, that's certainly something that's possible as well. So, yeah, those are those aspects. Just want to pick up on a couple of comments in the chat box. I'll come to you in a moment, Jessica. Just answering Usman's question. Yes, the second assessment can be done in groups. That's certainly been already advised. That's something that is possible. You can do the second assessment as a group exercise, whereas the first assessment is an individual assessment. So that's entirely up to you. There's already been a few students posting on the Moodle forum about that, looking for partners. So yes, that's absolutely. Okay, so that's that answer. Jessica, did you want to, have you got a connection where you can speak or?
Hello, can you hear me?
Yes, you can.
Yeah, great. I'm not even sure if you'll be able to answer them, the questions I have. But the first one is a little bit general. I don't think it applies too much to the scenario. And I think it's just a bit of general knowledge that I'm lacking. The other parties in the transaction, like the conveyancing solicitors and Philippe, they don't owe any duty to identify in the real world. Do people that's not something that's not answerable by you?
Can I just ask for a little bit more?
I'm in regards to the verification of identity. Obviously, the bank is required to verify identity. Is Philippe able to be held liable in any way for accepting because he's obviously a chain in the process, as is the conveyancing solicitors who lodge?
Right. So what I'm prepared to say in that context is, it's a matter for you to decide whether those persons that are acting on behalf of others have a role to play in that process or not, and what comment you wish to make about that. Yeah, that's how I'll respond to that.
Okay. And just this one is the other one is the question I had is the one that I thought you wouldn't be able to answer. But I have done a little bit of research. I've got a little bit confused in the question with the information provided about the clauses in the contract or the loan agreement. And I've done a little bit of extra research and found some other cases and bits of information. And that information is in Chapter 5 in one paragraph. It's not in our notes or mentioned in any lecture or tutorial. Do you think that I'm still on the right track?
Because it's not mentioned.
Do you think it's unlikely? Do you think, if it hasn't been mentioned in lectures and tutorials, that it's not real? It's probably not worth touching on or not worth going into?
No, not at all. I can't cover every aspect. I can't replicate the casebook in my notes and in my slides and in my lectures, right? I am trying to focus on the central ideas to give you the adequate grounding within the parameters of the nature of those resources. But, you know, if you have discovered, or you have your analysis and reading through the materials, the casebook, which is a prescribed book for the unit, you have unearthed something that you think is directly bears on the assessment or on the scenario, Jessica, then by all means utilise that. Because it doesn't happen to be in my notes, or it doesn't.
It just makes me think it might be wrong.
Sorry?
It just makes me think it might be wrong, incorrect.
Well, because it's
applying something incorrectly because it hasn't been a focus of your teachings.
No, I mean, I don't. I'm not a vessel of perfection, and I'm a long way from that. I certainly try to, you know, I've come with, you know, back a range of experience, and as both a lawyer and as an educator in this field and more generally. But I'm more than happy for my students to pick up aspects and features within the framework of material that I've given to you and apply it as appropriate. On that last point, which you said, oh, I might be wrong, whatever, I will always say to my students to trust your judgment and trust your instincts, okay? As lawyers, at the end of the day, that's what you've got to do. You've got to back yourself, basically.
Okay.
And your clients are actually depending on that. And that doesn't mean that you're always going to have the perfect answer or the answer, right? Because as you know, in law, there is, you know, often two ways of seeing things, and you'll have law and you'll have material that you can bring to bear, and your person on the other side will have different material to bring to bear, come with a different outcome. But if you have seen something that you think is relevant and you think it, you know, bears on the problem or the scenario or whatever it is, trust your instinct and have the confidence to believe that you've undertaken the relevant forensic task, you've scrutinised it against the facts in the scenario. And yes, you know, you're saying to yourself, I believe this is relevant, appropriate. I'm going to apply it.
Cool. All right. Thank you.
Okay, pleasure. Where are we, folks? 9:30. We've been going for an hour. It might be. I've had a long day. It might be time, I think. I hope that's been helpful to clarify and to iron out some of the wrinkles in the process. And you know, just the thing now, folks, is that, you know, it's Tuesday. It's due on Friday. Just, you know, do the best you can. Do the best job you feel you can within the time that you've got and that you can devote to the exercise. That's all I can ask. You know, I'm not asking you to have a mini breakdown over this. It's not the purpose of the exercise. I want to challenge you, but I want to believe that it's a doable exercise, that it's an exercise that's building good legal analytical skills, working with the dimensions of land transactions as they're evolving with technology, and also giving you some experience with that technology through the second part of the assessment, through the PEXA learning environment, a collaboration that I've been working away with PEXA for some time now, and we've been able to make this a reality. And let me just say to you on this, that PEXA are actually quite excited about this sort of development, and that it's being taken up in this way, and that students are engaging in this way and learning these skills. And so that's I think that's all for the good. So just, you know, take it in the terms in which the assessment presents to you, and just do your best. That's all I can ask.
You're definitely on the right track with that PEXA though, Michael, because one of the other things I'm doing, as people may know, is the eLaw module, and in there we're dealing with digital signatures and PEXA again as well. So that's rather interesting.
Well, there you go. So we might call it a night there, folks. And as I say, I hope that's been useful. And all the best with completing your assessment. And we will have our class on Thursday. We will come back to topic 4 on equitable and unregistered interest in the Torrens system. So until then, bye for now.